How's it going, everybody, and welcome back to Lead Therapy. A California judge has approved a lawsuit against Smith Wesson. The gun control group Brady is crowing over a decision by a California Superior Court judge to allow a lawsuit against Smith Wesson and a California gun store to proceed, despite arguments from the firearms manufacturer that the Protections of Lawful Commerce in Arms Act should preclude the litigation from moving forward. The lawsuit was brought by family members of victims of the shooting of the Shabbat Poway Synagogue in Poway, California in 2015. But the legal wing of Brady is taking a leading role in the litigation. Part of the group's effort is to use the courts to hold gun makers responsible for the acts of criminals. There are a couple of things worth pointing out. First, Brady alleges that Smith Wesson knowingly violated federal law regarding the sales of machine guns to the general public, even though the gun that was used by the attacker was a semi-automatic firearm. Brady's making the claim that Smith Wesson knowingly manufactured a gun that could be readily converted to fully automatic fire in violation of the National Firearms Act. The gun used in the Poway shooting wasn't modified to shoot full auto. But that's of no importance to the Brady's argument. If that legal argument were to hold up in court, then the Biden administration and the weaponized ATF would surely declare that all AR-15s and other semi-automatic rifles are also readily converted and must be registered under the NFA. And for those that are watching that are saying, Troy, that's not true, let me remind you that David Chipman, the gun control activist that Biden wants to put in charge of the ATF, has already said that in his opinion AR-15s should fall under the NFA. And Brady's is now trying to make the same case to the judge. Thankfully, the judge rejected Brady's argument, declaring that the product liability claim is barred by the PLCAA and dismissing the claim from the lawsuit. But unfortunately, the judge also decided that the Brady's second argument did fall outside the scope of the PLCAA, that Smith Wesson's marketing team were targeting youth with advertisements over social media and through video game-like commercials, despite the known risk that young people in that demographic are highly susceptible to that type of advertising and have disproportionately perpetrated mass shootings using similar firearms, and that the company's advertising violated California's law forbidding deceptive, untrue, or misleading advertising. Now, I want to make it clear the judge didn't declare that Brady's arguments are valid, but then the case can continue forward based on their claims about the company's advertising practices. And I think in most people's mind, it's the wrong decision, because Brady's argument, if successful, would basically prevent every company within the firearms industry from marketing to those under the age of 35. The vast majority of the owners under age 35 are law-abiding, just like the vast majority of gun owners that are older. It's a ridiculous argument, and the judge should have dismissed that claim as well. We all know this is a tactic used using litigation to try to bankrupt the industry. And most likely Smith Wesson will win this case, but at the cost of tens or hundreds of thousands of dollars. As always, please leave your thoughts in the comment section down below. And if you enjoyed the video, or if I gave you some information you didn't know, please like, share, and subscribe, and hit those post notifications. And I will see you in the next video.